Good afternoon, everybody. Welcome back to another session of Employment Law Q&A. My name is Chris Justice. I'm an associate with Samfiru Tumarkin. And as I've done before, I'm here today to hopefully answer as many questions as possible within the time allotted. So if you've got questions to do with your employment situation, you definitely want to get them in while I'm here answering those questions. It could be anything from wondering about how much severance is fair in your particular circumstance. Maybe you've got a question about a contract or something you're being asked to sign from the company that you're wondering about. Perhaps you're going through some issues in the workplace, maybe experiencing some harassment, bullying, or there could be some other toxic-like situation going on. So as I say, get your questions in. I'm here today to answer them. I actually did want to start off today just before some of the questions get in, to discuss a little bit about workplace harassment. It is something that unfortunately comes up very often, and I thought it would be helpful to kind of give those listening a general sense on what it really is and what to do in the event that someone is or you are experiencing harassment in the workplace. So first, in terms of defining it, I know a lot of people have different definitions as to what constitutes harassment. A lot of times people may think that if they are getting stressed out at their workplace, or maybe someone is breathing down the neck to get a particular project done, that can constitute harassment. But the word itself is defined, at least for Ontario purposes, through the Occupational Health and Safety Act. This would be a piece of legislation that employers are bound by. They have to ensure that those working for them have a healthy and safe work environment to work in. And in the act, in the legislation in Ontario, it refers to workplace harassment as any sort of course of vexatious comment or conduct against a worker that is known or ought to be known as being unwelcome. So it's a pretty broad definition, essentially unwelcome conduct that should be reasonably well known to the person putting forward that conduct, that it is toxic or that it does constitute harassment. So this can include things like spreading malicious rumors. You know, a lot of times people will hear things through the grapevine, oh, so-and-so, we want to get rid of them, or they're not good, or whatever. So there could be some workplace gossip or rumors that are getting spread that can constitute harassment. Any time where someone is excluded or isolated in a more social situation or even in a work situation, that exclusion can also be considered harassment, as well as, of course, making jokes, offensive gestures or statements, whether it's verbal or in writing, that can be harassing conduct as well. And of course, as well, any physical abuse or threats of any abuse can definitely meet the definition of harassment. It's also important to know that harassment can come from a one-off where it's particularly egregious what happened and has a long-lasting effect on the worker themselves, or harassment can come in the form of more of a continuous pattern of conduct. So it depends on the situation, but just because something happens once doesn't mean that it won't necessarily be considered harassment. It'll just come down to each case-by-case basis. There are, however, things that I would more consider not to be harassment, or at least on the border of whether it is harassment or not. So things like, where an employer will come to you and correct some sort of work deficiency, maybe provide criticisms, constructive criticisms, or maybe disciplining someone for an infraction that was committed in the workplace. That's not generally going to be seen as harassment. Even if the criticisms are negative, it's still not going to be seen as harassment if this is all being done and said in the context of managing someone's performance. So I think the context is really important. If it's in that context, less likely it's going to be harassing, even if it does cause someone a lot of stress. But there are also times where people are critiqued or put on a performance improvement plan, and the criticisms, the critiques are not actually merited, or the expectations being set on the person are unrealistic. So while a performance improvement plan can be definitely viewed as legitimate if it's done properly, If the criticisms or the plan is done in any sort of improper or egregious manner, then that also can still technically constitute harassing conduct. It's just going to come down to, in a lot of cases, whether the actions taken by management are ultimately reasonable. So like I say, there may be a question of what's reasonable or not, but when what's happening to you is more so in that work context, you'll at least expect there to be some pushback from the employer to say that they don't believe that's harassment. But it'll depend, like I said before, on a case-by-case basis as far as what is considered harassment or not. But those are some general guidelines or sort of an outline of what would or wouldn't be considered. If you're somebody, though, who has actually experienced harassment, in terms of the next steps, it can definitely be challenging, a bit intimidating, but it's crucial in terms of how you respond. So first of all, you have to recognize that harassment can take many forms. A lot of people may think in a more narrow-minded or sort of narrow viewpoint on what it is, but it can take many forms. Like I said before, jokes, even bullying, sexual harassment, could be some sort of discrimination as well, overlapping with this, that could constitute harassment. So you want to recognize, first of all, that you are being subjected to the harassment. Second thing is you want to document things. Document everything, keeping a detailed record of when you were harassed, who harassed you. It could even be notes that you write on a piece of paper off to the side, or if there's any emails or text messages that might be seen as harassing, you want to save that. And you also want to be mindful of whether there are witnesses involved. So did anyone hear a certain thing that was said or a certain thing that was done? Potentially gathering witnesses and statements on those witnesses' behalf can be also quite important. So document everything as far as you're concerned, though. You want to review the workplace policies. So there's going to be, I'm sure, a policy, well, there has to be, dealing with anti-harassment. And in that policy, it's going to often define what harassment is. It's going to set out the process that you would put forward a complaint. So there might be a certain person or individual that you may present your complaint to. And so in general, you want to try to comply with the company's harassment policy, because that way, not only are you making your voice heard, putting things on record, putting things rather in writing, you're also following the company's own policy when it comes to reporting harassment. And that's going to put even more pressure on them to ensure that they investigate the situation properly and that they do so in accordance with their own policy. And if there is something they don't do in accordance with their own policy, then you can just simply use that as another piece of ammunition to say that, you did your part, you brought forward the complaint, you followed the policy, and it was either dismissed or rejected, or the investigation in some way wasn't carried out in the manner that it should be. So you want to report it, whether it's to your supervisor, maybe someone in HR, depending on who the person that's harassing you is, of course. Sometimes the person in HR might be the one harassing you, and then you'll have to report it to a different individual, depending on the circumstances. So you do need to voice your concerns, however. You should also, probably most importantly, make sure you take care of yourself. So if you need to get any help from a medical professional, maybe you need to take a leave for stress, with your doctor's support, that can further substantiate the impact that the harassment had on you and potentially give you more options going forward in terms of what recourse you might have against the company. In the event that they say fail to do their end of the bargain, you can potentially go after them for your severance rights in full. Not only that, you can chase them potentially for punitive damages for failing to adhere to their own policy, as well as possibly some human rights damages if there is some overlap when it comes to harassment and discrimination. But also you want to contact an employment lawyer. You want to give us a call. We deal with harassment situations all the time. And so before really having any any main communications with your employer back and forth about the harassment situation, apart from documenting the instances themselves, you want to give us a call, because we can at least that way guide you through how to communicate best, how to voice your concern best, how to basically set yourself up so that the harassment or the bullying behavior gets eradicated from the employment situation, or if it doesn't, you can at least show after the fact that you did everything you needed to do, and it was just the employer who are the ones that drop the ball. So that's just a little summary, a little overview of, like I say, what harassment is, what it isn't, and some of the main steps that I think individuals facing these kinds of things should go through in order to, as I say, best protect themselves. With that said, though, I'll get into some of the questions, and if we have time later, I'll come back to some of what I wanted to talk about at the top of the show. I've got one in from Samuel Lee, who's asking whether an employer can ask you to reapply for a position once you hit 65. The role in question is senior management, and this person's been there for 20 years. So that, in my experience, would be quite an unusual thing to have happen, where you're working at a company for decades in a senior management role, and then when you hit 65, you're asked to reapply. You know, that would strike me as definitely the potential for human rights concerns to be there. It seems clearly to be connected to your age. Maybe the assumption or the perception is that those after 65, I don't know, somehow can't do the job that they once did. There used to be a mandatory retirement age. That's now been essentially eliminated. But perhaps this is roughly where the employer is coming from with its 65-year threshold, so to speak. But that raises some big alarm bells for me. I think that if you're doing your job and there's no issue in terms of you doing your job, there's no concerns as far as performing the job, just the fact that you've turned 65 on its own does not, in my view, justify asking you to reapply. You know, the idea then would be that your job is either no longer there or at risk of being lost. And if it's at all connected to age, then that's going to open up a big can of worms for the employer. So I would say, Samuel, give us a call before having any communication, or certainly before reapplying to a position that you've already been holding for many, many years. That it just doesn't seem right to me. And you could actually have some more options than you think. Given 20 years of service with the employer, if you're in a situation where you're being let go or discriminated against, you could get upwards of 2 years of severance, not to mention other possible damages for the way in which this has all sort of occurred, which again seems to revolve around an arbitrary number in terms of your age. I've got another one in from John on YouTube, who's saying that they previously worked on a contract for a junk removal business. Several months ago, they decided to start their own removal business, and they were threatened by their former employer that they would sue him or her. They've never signed a non-compete. Can I be sued? So first of all, non-competes in Ontario have now been eliminated. So if you find that there's a non-competition clause in your agreement nowadays, odds are that the courts are just going to reject it full right. And it shouldn't matter. And the reason why non-competes were eliminated in the province was because the courts and the law, they don't like situations where someone has an even harder time finding a job after they've been let go or after they've left their employment. So that's why non-competes in general were never really looked upon in a favorable light from the court's perspective, but also why they've been eliminated. If you haven't signed a non-compete with this company and you later on work for a competitor after you leave the company, there should therefore be nothing in your way to do so. It's completely fine to compete with a former employer that you might have worked for, especially if there's no non-competition agreement whatsoever involved in the picture. So just on the basis of you competing with your former employer, there wouldn't be any merit from what I see to any lawsuit against you. If there is a lawsuit brought against you for something that has no merit or has no basis in law to be even upheld, then your employer, your former employer, could actually be on the hook to have to pay you damages and legal costs for just bringing forward a vexatious lawsuit. So while anyone could potentially sue anyone, the question would more so be whether the prospects of that lawsuit would succeed. And it seems like they wouldn't. And as I say, in fact, it could go the other way against the employer for bringing that meritless lawsuit against you and potentially forcing you to have to go through a number of hoops before you can get that resolved. Appreciate the question, though, John. Thanks for that. I've got another question in from YYZ on YouTube who's saying, or asking rather, does the employment law mandate that employees sign an agreement when taking a family caregiver leave for more than 2 weeks? And no, so the law doesn't mandate that someone sign an agreement. The law does allow for certain types of leave to be given. And depending on which type of leave it is, the law will set out a certain bare minimum number of weeks or days that employers are to give to the employees. But having said that, the law only sort of sets what the bare minimums are. So if somebody wanted to take a leave, for example, a family caregiver leave that went past what maybe the bare minimums are, they can also do that. And depending on who they work for, the employer may be agreeable to paying them while they're off. The employer may be willing to have them take that time off more as unpaid days, or there could be some other plan or policy in your employment that allows for payment when certain leaves last for a longer period than may normally be the case. So it does sort of come down to what your employer's policies are and what they kind of offer when you compare it to what the law provides for, at the bare minimum at least. But in terms of signing an agreement, I always get a bit cautious when people are coming to me saying that they're asked to be signing some sort of document that allows them to take this or to take that. And then you find in the rest of the document, there's other, language in there or clauses in there that are actually very detrimental to you. So you might think in one case, oh, I'll sign this and I'll get the leave that I want, but you may unknowingly be giving up a bunch of rights that you had before that. So YYZ, just because they're asking you to sign something, I would say give us a call at least and have us take a look at it, just to make sure that you're not signing away any rights that you don't want to be signing, because that would be obviously a big issue. If it's just a matter of taking a couple more weeks or a certain time frame off work and they want you to sign something to that effect and there's literally nothing else, then it may not be as much of an issue to sign it. But definitely give us a call. My alarm bells sort of ring always when these things are asked to be signed. But thanks for your question, YYZ. I've got another one in from Ash MK on YouTube, who's asking or saying that they're attempting to return to work from a parental leave and their employer is saying that they don't have space and to check back in a few months. Can they do this? Do I just have to wait? So that could be a problem for your employer. If there was an understanding, for instance, that somebody was going to take a parental leave, a maternity leave, paternity leave, whatever, for a certain period of time, first of all, there's going to be guidelines, again, as far as what the law says those leaves can last for. But if the person's ready to come back and the understanding is that maybe they had told their employer ahead of time that the return to work date is going to be a certain day in the year or in the month, and then the employer comes back and says, we don't actually have your job for you here, check back in a few months. Well, now it's all of a sudden turned into a situation where the understanding was I would take some time off and come back. You agreed to this. Now you're not upholding your end of the bargain, and you're essentially and potentially failing to accommodate my return. And then you get into the whole question of, had I not taken this parental leave, would I be in this situation? Would I have a job still? Would there be something for me to be working on? And is it only because I took this parental leave that I'm now without a job essentially and sort of in limbo? And if that's the case, then you get back into the realm of potential discrimination, about a failure to accommodate or a failure to have an employee return from a leave that may have been negotiated previously. And a lot of times employers may just push it off and say they don't have something in hopes that you kind of let it slide. But if that was the understanding, then I think you have options. You can put them under pressure to have you come back. And if not, potentially at least go after your full severance and then some. But definitely give us a call as well. It seems like we'll need to flesh out a bit more of the information there, Ash. But appreciate your comment. Got another one in from Rodriguez on Facebook, who's saying that they had been written up for breach of conduct twice because they questioned some irregular dental billings. So first of all, I don't think that's a breach of conduct on its own. And if the write-up is in almost a retaliation for bringing up unethical or illegal things, then that's going to be a can of worms opened up that your employer is now going to have to address, because you could definitely look into the issue of reprisal and retaliation just on that basis alone. It'll depend on what your questioning about the billings were in the context, but that seems on the face of it to be sort of retaliatory in my view, anyways. You file a complaint and request an investigation, and also file the complaint for bullying and harassment in the workplace. and you come to find out that they put you on an administrative leave with pay for 1 week because someone complained that you, I guess that you were bullying somebody. You say that it's all untrue and you believe there's retaliation. What can I do? Pretty sure they're trying to fire me because I filed an external complaint and now coming up with bogus allegations against me. So yeah, again, that could be another example of retaliation. I'm not sure what this complaint against you is regarding bullying. I would definitely want to know more information about that. I mean, if I were in your shoes, I'd be trying to sort of flesh out where this came from or what the allegations are. Obviously, if you're being complained about, you have the right to participate and respond to those complaints. So you're definitely going to want to get some of the particulars there. On the one hand, if it's legitimate, that's one thing. But if it's not, and through your questioning, you find out that there's nothing really there, then again, it would go towards the retaliation or the reprisal situation. It seems like it is going on and might just be a continuation of their pattern of conduct. Also, you filed your own complaint for bullying and harassment in the workplace. So another question would be, what happens with that complaint? Are they going to investigate it properly? Are they going to do something about it? Are they going to find in your favor that there was harassment or bullying going on? So that's another piece to it in terms of how they respond. It could add or give you more ammunition as far as any potential case is concerned. So there does seem to be a lot going on. Again, I would also recommend you get in touch with us, at least set up a consultation where we can chat to you about your situation, whether it's the initial point when you question the billings, your own investigation or complaints, the ones you're facing in response, also being put on administrative leave for 1 week pay. Now the question is, how long are you going to be on leave for? You know, are they going to extend the leave? Are they going to stop paying you while you're on your leave? So yeah, there definitely seems to be a lot going on. All the more reason to give us a shout, and I'm sure we can help you out and at least give you an idea of kind of what paths you can go down and what all your options are. Got another question in from Burrows on YouTube, who's asking whether an employer can place you on leave while they review an accommodation request. I guess it would depend on what kind of leave they're putting you on and how long the leave is for, as well as whether they're paying you while you're on the leave. I think if they're in a legitimate way trying to accommodate you to the best of their abilities, but the accommodation requires a little bit of digging into, and maybe you can't currently perform your job until they get the accommodation set up, and they want to put you on a paid leave while they're accommodating you again in good faith, that could be a possible scenario, which may not be bad. But if they're going to put you on an unpaid leave, for example, and take a bunch of time for an accommodation request that shouldn't be taking nearly as much time as it should, and you're just sort of in limbo, not getting paid while you're waiting on them reviewing your accommodation request, right? Because it's not even, it doesn't even seem like they're confirming they will accommodate, then yeah, you're sort of stuck in limbo waiting to see whether they're going to say yes or no. And depending on what the accommodation is, and they say no, there could be another failure to accommodate situation going on that could also open up a number of options that you may have as far as deciding just to get out of there and go after your full severance, or possibly waiting while they accommodate you with getting full pay. So give us a call as well, Burrows. Just want to make sure that at least they're doing everything they need to do, and that none of this is coming from an area of disingenuousness or just some sort of delay tactic, designed to frustrate you, which unfortunately a lot of times happens. I've got another one in from Ladayan Williams in Alberta. Worked for over 5 years, but while working has gone through harassment and gender bias. Talked to both HR and operations manager about the harassment. Ultimately went to a doctor due to constant headaches, anxiety, and chest pain. And I guess they were giving more responsibilities and less pay to you, and you also got laid off temporarily. So yeah, there seems to be a lot going on here. I'm not sure if you filed any kind of formal complaint against those who were harassing you, whether to HR or the operations manager. If not, I would definitely recommend doing so. It seems like you had maybe had to take some time off work due to the stress and anxiety that it was causing. So I think depending on what your doctor says, you definitely want to go along with the doctor's advice. And if you need to take more time off, then so be it. You did mention, though, that you got laid off temporarily. So I'm not sure if that just happened now. Oh, I just got your next message here. Right after returning back to work about a week or two before the date that was given, they called me back to work. They laid me off permanently. They only gave me 4 weeks pay. So, okay, so they've let you go. They've offered you 4 weeks. There's probably a good chance that just on the severance front of things, 4 weeks is not going to be enough. So I would definitely get in touch with us. We have offices out there in Alberta as well. You can get in touch with us to figure out if, first of all, the severance that you were offered was fair. So that's one thing. Whether you've been unfairly stripped of the bonus, that's another. And also why you were let go. Was it because of the complaints you made, maybe the harassment concerns that you voiced? And is this also another instance of retaliation? Lo and behold, you go through all this and then days or weeks later, you're let go. Of course, part of you is going to think that some of this had to do with me raising forward legitimate concerns. And if their way of sort of brushing things under the rug is to just let you go and get rid of the problem, then that's going to be a huge problem for the employer. And not only are they going to have to likely pay you more severance and your bonus potentially, but also be on the hook for those punitive or aggravated damages for the manner in which you were let go. Because sometimes it's the way somebody's let go that is also a problem and can actually lead to additional damages being awarded. Got a follow-up from Rodriguez Sim saying management said they can't tell who made the complaint. The complaint is then they complained about possible unlawful billings. So maybe you don't know or can't know who complained about you, but you do need to know the particulars of what the complaint is in order for you to respond. So while there may be certain details they can have remain confidential, in order for you to fully participate in the process, you need to know the particulars, because unless you get your side of the story put forward, they can't conduct a full investigation. And if they don't give you the information you need to effectively respond and potentially vindicate yourself, then that would go towards more of a failure to conduct a proper and fair investigation. Thanks for your question, though. I've got another one in from Claudia, who's saying that they're returning to work after a medical leave. They're an on-site case manager, and their caseload before was a max of 20. Before they left, they were often the only one dealing with a potential caseload of 62 clients. How can I address that upon my return to work? I only want to work my assigned caseload due to the stress. Yeah, so I think if you were working a 20 client caseload, or that's the policy and the procedure as far as normally what a case manager would have, then you definitely want to voice your concerns and say that, you're ready, willing, and able to do your job, and you're ready, willing, and able to work out the max number of clients caseload, which is 20. But that, as you understand, there's an expectation perhaps upon your return that you're going to deal with 62 clients, and that's not what you signed up to do. And you're looking for there to be maybe an accommodation or a reallocation of those clients. I'm not quite sure how you got from 20 to 62 clients, but if it is a term of your employment that the max is to be 20, and this potential caseload of 62 is something that only came as a result of recent days or months, then yeah, you definitely want to make sure that upon your return that the expectations are managed. So I would be sending a note to the employer, just trying to set that up so that on your return, you understand that, you're going to be dealing with the 20 caseload max, which is the max for any case manager. I think if you can tie it back to what in general case managers are expected to do and what the others are doing and what their maximum is, then it would sort of paint a picture of unfairness, of course, for you to be the only one with maybe triple that caseload. So if you come at it from that perspective and that frame, hopefully the employer understands and accommodates. But at the end of the day, also, if you need accommodation and you literally or physically cannot work that big of a caseload, then getting some support from your doctor as well, to say that, look, this is a person who can handle, this amount of clients, in line with her duties, but, nothing further. I would recommend she not go above and beyond that. Then you'll have some medical backing for your situation, which can put even more pressure on the company to, do the right thing and to accommodate you rather than it just being, something without a medical sort of context or anything like that. But Claudia, I would say give us a call as well, even if we have to set up a consultation with you just to go through it all. I do want to make sure that you on your return or before you return, you communicate what you need to, and that you kind of present your case in the best light possible so that you can at least go back to a situation that's tolerable and something that you can handle, and not going to simply result in you potentially going back off on another medical leave after getting stressed out. But I appreciate your question, your situation. Thanks very much. I see here that we're out of time though, so that's going to do it for my time today. I appreciate everyone who joined, all your questions. Thank you very much. We, as many of you know, have this going on all the time. So just below there, you'll see this Wednesday. So just 2 days from now, Lior Samfiru will be here at 1 o'clock Eastern. So for those that might have questions I didn't get to or have by that point, definitely tune in to speak with Lior, and he'll do his best to answer all the questions, I'm sure. Having said that, though, thanks again for joining. Hopefully everyone has a great rest of their day. Do take care. All the best. Bye for now.